Hello, everyone, and thank you so much for joining us this afternoon. My name is Nina Holatova, and I am a lawyer and program coordinator at the Community Legal Education Association, also known as CLEA. For those of you who aren't familiar with what we do at CLEA, we are a nonprofit charitable organization, and our mission statement is unknown rights are not rights at all. We've been working to improve access to justice by providing education, information, and other resources to Manitobans about their rights and the law. And we have been doing this since 1984. So that means we are very much looking forward to celebrating CLEA's 40th anniversary next year. We offer webinars every spring and fall on a variety of topics. And today's topic is family law, child support, spousal support, and enforcement. Just a couple of pieces of housekeeping. Today's presentation is being offered in webinar format, which means everyone is muted and cameras are off by default. We will have a dedicated time for some questions at the end, but feel free to send your questions during the course of the presentation by using the Q&A function so that we have some questions ready at the end of the presentation. However, if you do have a more specific question that pertains to your particular legal situation, I encourage you to reach out to CLEA's Law Phone-In and Lawyer Referral Program, where you can speak to one of CLEA's lawyers for free and get some information. I also kindly ask that everyone completes our very brief survey after the presentation concludes today. As a nonprofit, feedback from our participants helps us improve the quality of our programs going forward, and it is also invaluable for our funders. So if you can fill that out, we would greatly appreciate it. With that being said, I would now like to introduce our presenter, Andrea Dodgson. Andrea received her call to the bar in 1996 and has practiced at Dealey Fabry Sellon, now known as DFS Kaneski UnRuh LLP, for over 25 years. She is co-managing partner of the firm along with practicing law full-time. She primarily practices in the area of family law, including divorce actions, legal separations, prenuptial agreements, spousal agreements, child custody and support disputes, division of family property, adoptions, and guardianships. Andrea's philosophy is to resolve family disputes as much as possible through negotiation and discussion, but she is qualified and regularly attends at court to litigate unresolved issues. With that being said, we are so pleased to have her here today. So without any further ado, I will pass it over to Andrea.
Thank you, Nina. I appreciate that. I'm glad I can help you today and inform. Looks like we have over 30 participants, so that's good. And I'm glad we can do this by webinar as well to allow more people to attend. So as Nina said, I've been practicing law now since 96, so 27, 28 years, getting long in the tooth, and lots of things have changed in family law since I first started practicing as a baby lawyer. Definitely the support obligations in Manitoba have changed quite a bit. And starting first of all with child support, you can go to the next slide, Nina. The child support guidelines, if you haven't heard of them, have been in place since 1997. So they've been around for quite a while now. And basically it's legislation that indicates how much someone has to pay in child support, how you determine someone's income, what kind of financial disclosure is needed, what other expenses have to be paid. And part of the child support guidelines is what I call a child support table that basically says if the payor, so the person paying child support, makes so much per year, they pay so much per month for one child, two children, three children, how many children you might have. And it's a very easy table to look up online. I have the website there at justice.gc.ca, or you can search up Child Support Lookup Manitoba. And on the right of the screen, you can see that will pop up, and you just enter in what the person's income is, how many children, and the province, and it'll give you a number at the bottom for child support amount. So you can go on there and put any number, any amount of income, any number of children with Manitoba, and I'll tell you what the table amount is for that family situation. It's not as simple as that. The child support guidelines are quite intensive, but this is the main part that most people look at is the actual child support table. Next slide, Dina. So the first thing that lawyers or separating spouses have to figure out when determining child support is what the person's income is. And it might be necessary to determine both parties' incomes if both parties share custody or share parenting time with the children. And I'll talk about that a little bit later. But first of all, the guidelines do talk about how to determine income. The easiest way is if the person paying support is just a straight employee, that they get a T4 slip at the end of the year, a straight hourly wage or straight salary. There's your income. That's easy to evaluate and assess. There might be some deductions. So if the person has to drive a car for work, they drive their personal car and have a car allowance, that may come off their employment income. Or if you pay union dues. So if the nurse or the teacher are paying union dues of $1,000 a year, that will also come off their income to determine income for child support purposes. But that is the easiest classification of income to determine, of course, if you have it straight T4 income. There's also other forms of income, of course, disability income. So if someone's not working because they're on disability, the amount of disability might be easy to ascertain, but then we have to look at whether it's taxable or not. So if you're getting disability income and not paying any taxes on it, then the lawyer or the court will gross that up to an equivalent gross income, because these guidelines are based on gross income before personal taxes are paid. So if your gross income is $80,000, you put in the $80,000 number, not your net take-home pay. So we look at disability income to see if it's taxable or not, because that might make a difference. If you have corporate income, so for example, if the mom is the one paying support and she owns a business, we'll look at the financial statements to see if her income is properly reflected in her personal tax return. So when you have someone that's operating a corporation or a business, they can sometimes pay personal expenses to the corporation, which are okay for tax purposes, but might be added back to their income for child support purposes. So, if the payer is the husband and he owns a construction business and he runs all his vehicle expenses to the corporation, some of that's legit, but it's actual business expenses for his work. Other is personal, using his truck for personal expenses and personal errands and personal reasons. So they might add back some of his his vehicle expenses back to his income for child support purposes. Those are just some examples. It could get quite complicated when someone has corporate income, and that's where we have to get all the financial disclosure. We need to get tax returns, financial statements from the corporation. Sometimes an accountant gets involved to help tell us what's the available income from all sources. So like I said, it could get somewhat complicated. There's also a section in the guidelines that talks about imputing income. So imputing income is, your tax return might only say $20,000, but if maybe you're underemployed, maybe you have a degree in finance, but you've chosen to work at Tim Hortons, and so you're intentionally underemployed, the courts can sometimes impute income to the payor to say, you should be able to make more money, you can do what you want, but we're going to say you're able to make $80,000, so we'll make you pay based on $80,000. So that's one classification where one subheading, the court will look at if you're intentionally unemployed, they may add income back for purposes of child support. Also, if the person is exempt from paying tax. So, for example, if someone Indigenous is working on a reserve and doesn't pay tax on their income, that income is grossed up to a higher amount because the guidelines are all based on gross income numbers. So if you're on a reserve making $50,000 net, maybe it'd be grossed up to $70,000 because after tax, you would take home $50,000. So that's one of the reasons that they would impute income to the payor. Another reason, if they live in a different country and pay different tax rates, then there'll be an adjustment. So for example, in Canada, if your tax rate at $80,000 is 35%, but you live elsewhere, you don't get taxed as much, there'll be an adjustment to make it, compare apples to apples, because all these guideline amounts are based on Canadian incomes and Canadian tax rates. And there's different tables for each province because each province taxes their income earners a little different. So we use the Manitoba table, obviously in Manitoba, but if the payer lives in the States and doesn't pay as much tax, there'll be an adjustment to their income. Another time that the court would impute income is if income's being diverted. For example, if you have someone that's running a business and they, through the corporation, pay for their son's hockey or pay for a family trip somewhere that's not work related, the court can add back that income, that expense, to the person's income because it was really to pay personal expenses, not business expenses. And that kind of ties in with the next one, which is unreasonable deduction of expenses from income. So, for example, if you own a business and you deduct all your cell phone expenses, even though you use a cell phone for personal and business, the court may, CRA will allow you perhaps to deduct all your cell phone expenses for work purposes from your tax return for tax purposes, but the court will say, well, some of that is actually personal, so we're going to add back some of that income, some of that expense to your income because it's paying a personal expense for you. And then a couple other examples. If you get a lot of income from dividends or capital gains, there might be an adjustment for that to your income. Or if the payor is a beneficiary under a trust, that may change the amount of income for child support purposes. So it can get complicated depending on the situation, but the main focus is determining what someone's income is to be able to slot it into the tables to figure out how much that person pays per month for one child or two children or three children, however the case may be. Next slide, please. I hope my voice holds out. I've got a cold. But the next thing to determine is if someone has majority parenting time with the children, it used to be called custody. So it used to be primary care and control. The legislation has changed its terminology. So now it's called parenting time. So if the one spouse has majority parenting time with the children, so 60% of the time or more, then the other spouse pays the straight table amount. And going back to the first slide, I think it was $60,000. I had a number in there. So if the payer spouse who doesn't have majority parenting time makes $60,000 gross per year, for two children, they pay $850 per month. That's the easiest situation when the person when one parent has majority parenting time. And that table amount of support includes money to help pay for children's school supplies, fees, clothing, food, housing, ordinary activities such as swimming. A typical swimming session being $100 or so. That's sort of included in the base amount of child support that's paid. On top of the base amount of child support is what we call Section 7 expenses, and I'll get into that a little bit in a little more detail later on. But the base amount of child support does cover, like I said on the second line there, school supplies, fees, clothing, food, utilities for that child. The tax benefits for the person with majority parenting time, you would get the Canada Child Benefit based on your income. And if you separate 3 months after separation, you can phone Canada Child Benefit, CRA, and tell them that you're separated, and they will readjust what you're getting in child care benefit based on just your income, not the family income that it used to be. There's also tax benefits. It used to be called equivalent to married spouse. It's been called eligible dependent now for a while. But if you are living just with you and your kids and you're not remarried or not living common law, you can claim one child as equivalent to married spouse, so you pay less taxes on your tax return. Everyone gets a tax break. You don't pay tax on the first $13,000 you make. And if you can claim a child as a dependent, you don't pay tax on the next $13,000 you make. So it could be a significant savings of a couple $1,000s a year if you're able to claim the eligible dependent if you have children living with you. So that's what happens when you have majority parenting time of your children. Next slide, Nina. What is happening more and more often these days is what we call shared parenting time, which the parties either have exactly 50-50 or something very close to it, like a 60-40 or better split. So a week on, week off schedule, for example, would be 50-50 time, and that will affect the amount of child support payable. At that point, we need to know the incomes for both parties. So if it was majority parenting time, the person with care and control of the children primarily, their income doesn't matter so much. It's just determining the payer's income. But with shared parenting time, we need to know both parents' incomes. So that's going through all the steps to figure out what their income is. And then usually it's a set off table amount. So we look at, say, use my earlier example, if the husband makes $60,000 and there's 2 children and he has to pay $850 a month, we would then look at what the mom makes, what she would have to pay for 2 children, and it's the offset amount. So his amount being $850, if she has to pay $350, then he pays $500 because that's the offset amount. And then on top of that, I usually have clients enter into an agreement, or the court could order that on top of that, the parties will also share other expenses, such as school fees and supplies, more expensive clothing items like outerwear or footwear, share activities, share health and dental expenses, and share education expenses, all on top of that set off amount that would normally be paid. That could be identified as a set amount each month. So it actually says the payor pays an extra $50 per month for these expenses. Or it could be a situation where the parties exchange receipts. 1 month, the husband spent $100, and the same month the wife spent $50. So she would owe him half of the difference, so that to make it equal in sharing the expenses. In shared parenting situations, both parents can get the child benefit from CRA. The one parent would get, based on their income, but half the benefit because they have the children half time, and the other parent would get half the benefit based on their income. So net is probably helping out the family more because they're both getting money from CRA, and it's just based on your individual incomes, and it's split at that point. So the wife will get the deposit to her account every month, and the husband will get the deposit to his account every month. The equivalent to married spouse claim that we talked about earlier is a little more complicated because CRA has some funny rules about who can claim that. Right now, if anyone's paying child support, they don't let that person claim the equivalent to married spouse unless the agreement or the court order is worded very specifically. But the person receiving child support would be able to get that claim. Sometimes we can word it such that both parties would get that claim. So if there's 2 children, the husband can claim the daughter, the wife can claim the son, or vice versa, and they can both get that benefit. If it's only 1 child, then you just alternate year to year. But again, there's some very specific CRA rules that might disallow the person who actually pays the support, like the offset amount of support, usually the higher income earner, from being able to claim that equivalent to married spouse credit. And that's certainly something to talk to your lawyer about to see how it can be worded properly to enable both parties to get that claim. Okay, the next slide, Nina. Another situation, I often have clients that they're not sure if child support extends beyond age 18. And it certainly can go beyond age 18. Basically, the test is whether the child is self-sufficient or not. So if a child is going to school full time, they're still dependent on the parent and they're still entitled to child support. Or if the child is, disabled in any way and can't work or can't go to school, then they may be considered dependent for a very long time and entitled to child support for a long time. So there's sections in the there's sections in the child support guidelines that talk about adult children and how that is organized and how that is paid for children over the age of 18. Over the age of 18, there's different factors that are taken into account. the court will look at what's reasonable for the child to contribute. So, if the child is working part-time, making $10,000 to $12,000 a year, it may not be the full table amount of support. It might be something lower, depending on what the child is doing and their ability to pay their own expenses. And then on top of that, it might be the child support amount plus a contribution to the child's tuition if they're going to school. Attending school full time, for the most part, is considered a 60% course load. So a normal university year is 30 credit hours. So if a child is taking 18 credit hours during the year, they would be considered full time for child support purposes. If they're only taking, one course or 6 credit hours, then they're not considered full time, and they would not usually not be entitled to child support. So I have a lot of files and have seen a lot of circumstances where a child might take a year off of school, so maybe they don't get paid child support for that year, but when they go back to school and re-enroll, they may still be eligible at that point. Manitoba courts will sometimes say that the child support ends after the first degree, although that's not set in stone. It may extend beyond that, because right now, if a child gets a degree in Bachelor of Arts, you can't necessarily get a decent job like that. They may have to go on and get other education. So typically it ends after the first degree, but it can often go on beyond that too. And then next screen. This is the Section 7 expenses I was talking about. So we've already determined what the base amount of child support would be, but on top of that would be extra expenses that I have listed out here. The most common ones are daycare costs. So if a parent has to have the children in daycare to either go to school or go to work, then the parties have to share the net daycare costs. So if you get a tax receipt from your daycare provider, so at the end of the year, you get some money back for your daycare expenses, the court will look at the net daycare cost. And then Section 7 expenses are shared proportionally based on your incomes. So if both the husband and wife are making, $80,000, they're going to share that expense 50-50. If the husband's making 100 and the wife's making 50, then it's shared proportionally. So the husband pays 2/3 and the wife pays 1/3. So just a mathematical calculation. That's not exactly, it doesn't have to be equal. It can be based on proportionate incomes. So the net daycare cost, if you're paying $500 a month in gross cost and you get some tax money back at the end of the year, so really it's only $400 a month, then the parties will pay proportionally based on their incomes for that cost. Daycare is easy to figure out the cost per month. So normally in an agreement or a court order, we would say, that the payor would pay X dollars. They pay an actual amount, a set amount per month towards the daycare costs. There's also health and dental premiums. So if one party is paying, the health and dental premiums through work to have the children on their coverage, that cost could also be shared. Health-related expenses over $100 per year. So if a child needs physio, is over $100 per year, that's also included and paid on top of the base amount of support. And that's the net cost. So if you're able to claim through your insurance, physio is $80 and your insurance covers $60, then the $20 would be shareable. And that's the same for prescription drugs, dental care, glasses, maybe this is special therapy, anything along that lines, health related. Number 4 there, extraordinary expenses for primary or secondary school expenses. So if the children are going to a private school and there's private school tuition, or a child's attending public school, but they need tutoring, that would fall into this category. And the whole test really is what's reasonable in the circumstances. So, depending on the party's incomes, it may not be reasonable to send a child to a $15,000 a year private school. If both parties are only making $60,000 a year, that's probably not realistic. So all of this is based on reasonableness of the expense. Number 5 could also be post-secondary expenses. So if tuition for university is $6,000 per year, the parties may have to share that expense proportionally based on their incomes. Sometimes I see situations where the parents want the child to contribute too. So maybe the child pays a third, the mom pays a third, and the dad pays a third, just to have the child help out with some of the expenses. Or it could be, there's RESPs that the parents have saved or the grandparents have saved. So after those RSPs are, depleted, then the parents will share the tuition expenses proportionally based on their incomes when that fund has been depleted. Number six, the last section 7 expense is extracurricular expenses. And this is a clarification. It's called extraordinary extracurricular expenses. So there's lots of case law on this on what extraordinary means. So I mentioned earlier, if you have your child in swimming lessons and they're $100 a session, that would be sort of an ordinary expense that the child support table amount would cover. But if you have a child that's playing elite sports, they're in soccer, they're in hockey, or they're in dance, and the expense is $6,000 a year, then that would be extraordinary extracurricular expense that the court would then could possibly have both parties contribute to based on their incomes. Again, proportionally based on their incomes. And the overall test for all of this is the expense necessary, and is it reasonable considering their incomes and their spending habits during the relationship. So, if you had, little Johnny in high level hockey when you guys were living together and your incomes can support that, the court would probably still require that as an obligation for both parties to contribute post separation. But if you didn't have, Johnny in any sports and suddenly the one person separates or the couple separates and suddenly they go into $10,000 a year for hockey expenses, but the parties aren't making that much money, the court may say that's unreasonable. If you want to have your son in hockey, that's fine, but you can't expect your spouse to contribute. So there's a lot of case law in this area. It can be it usually is straightforward, but it can be complicated depending on what the expense is, depending on the child's needs, and depending on the parents' incomes. So that's one thing that lawyers and judges consider when they're looking at child support for children. That's child support pretty much in a nutshell. It's high level information. Nina, are there any questions related to child support that maybe I can answer right now?
Yeah, we do have a few questions. Some really good questions, actually. So the first one we have here is, can owed or past due child support 2+ years be included in an equalization payment?
I'm assuming that would be like a property equalization payment.
Mhm.
Okay. Yeah. So if you're negotiating, when people first separate, child support may not start flowing right away. Maybe they'll, the person can't afford to pay it, or they don't have a lawyer yet, and they're just not paying. For sure, if at the end of the day we figure out, well, this was your income, this is what you should have paid. We do the calculation, maybe you owe $5,000. Yes, that can be incorporated into a property equalization payment. So maybe more is owed, that $5,000 is paid as part of property, or maybe the person who has to pay the property equalization payment is the one to receive support, is the one to pay support. So they would have to pay more. So yes, it can be incorporated into an equalization payment. It just depends on what the amount is and who has to pay whom. But that's certainly something the lawyers can take care of. And if it's not paid in a property equalization payment, then there can certainly be an agreement that this is the amount owing. Let's say it's $10,000. The person can't pay $10,000, at the drop of a hat. You will pay $100 a month until paid in full. Or maybe from your tax return, if you get a $2,000 tax return, you're going to pay that to pay towards the arrears. So child support court orders and agreements often have arrears that were owing that should have been paid before, and there's a schedule for payment.
Okay, the next question that we have here is, if someone is obligated to pay child support in 2 or more separate files, is their income adjusted to factor in financial requirements to multiple receivers? Example, if income is $45,000 and table amount is $376 a month, then what is the next child support obligation based on? The 40,488 or again the 45,000. So I guess just asking if there are multiple recipients, multiple let's say one parent is paying child support to multiple parents with children of multiple parents, how is that factored in for child support payments?
Normally, it's based just on their income. So if you have a 10-year-old child from your first relationship and now a 2-year-old child from your second relationship, you would have to pay the table amount for both children based on your income without a deduction for your obligations for your first child. Because the courts will always look at the child support as a right of the child. So they're not going to favor the first child over the second child. So the second child gets less. There is a section in the child support guidelines called undue hardship, and it's really not used very often. There was lots of case law early on kind of testing that concept. But you don't see very many cases of undue hardship, but this would be one, like if you have other support obligations and there's a mathematical formula talking about standards of living in each house, if you can prove undue hardship and that your income is low enough, the court may adjust the amount of child support for both children. You could also have undue hardship, for example, if you're married and living together with your spouse in Winnipeg and the spouse moved the children to BC, so now you have higher costs to exercise access to your child, the court may say, okay, that might be undue hardship, and they might change the amount of child support payable. So we really don't hear about undue hardship very often. It's a kind of complicated formula to see standard of living in both houses, based on taxes and how many people live there. But if you meet that threshold, the court may reduce the child support for a second child, or in a situation where there's expenses to travel to see your child. But for the most part, your income is your income because, had another child knowing you had other support obligations, first of all. So they're not going to favor the first child over the second child or first family over the second family.
Okay, we have another question here. What if only the payor is paying for Section 7 expenses, but the recipient is claiming these based on CRA rules? Is this factored in any way?
The only thing I think of, the only thing you can claim for CRA really is daycare costs. There used to be the child fitness credit. I don't think that's even in existence anymore. But if you're going to claim the daycare costs, you have to have majority parenting time of the child. So the payor, if they don't have majority parenting time of the child, they're not technically allowed to claim that daycare expense. So that would be the recipient spouse would be able to claim that. We figure out what the net cost is, and then the payor shares the half or shares their proportionate share. But normally it's the recipient spouse gets the tax credits. That's just the way the CRA Income Tax Act is set up.
Okay, we do have a few more questions here. Somebody is asking, I've never received child tax benefit. How does that factor into child support?
It doesn't factor in. If you get the child care benefit, it doesn't affect how much the child support has to be paid because child support is based on the other party's income. It might affect spousal support because I'll get to that. There's other more complicated formulas to figure out spousal support, and it'll look at net incomes. And if someone's getting a lot of child care benefit, that'll affect their net income, but it doesn't affect child support payable. That money is paid to the parent entitled to it, and it's money in their pocket to help raise the children.
Okay, somebody else is asking, what if the other party's income in both files is greater than $150,000?
The guidelines go up to $150,000. That doesn't stop there. If you go into that first screen I had where child support lookup and you put in $175,000, it'll give you an amount based on 175. So there's some situations where the payor might be making $1 million a year, and the court would then say that's excessive and maybe reduce the amount of child support payable. But just over 150, you're going to pay based on the guideline amount. And the table has built into it a formula. If you make over 150, there's a formula for the money you make over 150 to add to the base amount.
Okay, we have two more questions here, so maybe we'll just do those two and then we'll move on to the next section. Someone is asking, what if the debtor has been late 8 months in paying due child support? What can I do? So I guess asking about enforcement.
Yeah. I was going to talk about maintenance enforcement later, but yes, if you have a child support order or a spousal support order or an agreement, you can register with Manitoba Maintenance Enforcement. They will open a file for you, and they will keep track of all payments and enforce the court order or agreement for you, so you're not having to chase that person yourself. And they have a lot of enforcement mechanisms. So if someone is not paying child support, they can garnish wages, they can garnish bank account, they can take away their license, they can take away their passport, they can call that person before the court to explain why they're not paying child support. In extreme circumstances, that person can be jailed for not paying child support or spousal support. That is extreme. They would have to be like intentionally not paying, like they have the means to do it, but they're choosing not to. So there could be what we call a show cause hearing. That the payor has to show a valid reason why they're not paying child support, or they could end up in jail. So, like I said, it doesn't usually get that far. But maintenance enforcement has the means to be able to collect the support for you, and they also keep track of all the payments so that everyone knows how much is still owing and who's paid on time, or if there's anything outstanding. They can also charge interest and costs for them to collect. So if they had to file a notice of garnishment to garnish someone's bank account, they can charge the payor the cost of having to do that legal action. But definitely, if you have a child support agreement or court order, get it registered to maintenance enforcement, and then you're not having to chase that person yourself.
Okay, we have one more question here. If your ex-spouse remarries, is their new spouse's income considered in calculating child support payments?
Usually not. Usually it's based on just the payor's income. It might be a factor if there's shared custody, because shared custody isn't automatically the set-off amount, although that's kind of what lawyers have ended up doing over the years. But they could look at all the circumstances in household A and all the circumstances in household B and decide that it would make sense that because someone's remarried and that new spouse makes good money, his or her expenses are reduced because they're sharing now and may allow for more child support to be paid. So the usual answer is no, although there's some circumstances where you can look at total household income to determine if child support should be higher.
Okay, that's all the questions that we have for now. If anybody does have any other questions, feel free to put them in the Q&A and we will get to them at the end of the presentation. Otherwise, I will let Andrea continue.
Okay, so moving on to spousal support then. Spousal support is more complicated because it's not every spouse is entitled to spousal support, whereas every child is entitled to child support. The first kind of hurdle to get over, if you're the one looking for spousal support, is are you actually entitled to spousal support? So there's kind of two areas where you'd be entitled to spousal support. One is what we call compensatory, so like compensation. In traditional long-term marriages, if the husband was the one that worked full time and the mom stayed home to care for the children and didn't pursue her career, and then they separated 15 years in, and she doesn't have the work experience to go out and get a better job, then that would be compensatory spousal support, compensating her for not being in workforce and being entitled to spousal support to make up for that lack of experience, lack of work, lack of pension. So that's what we call compensatory. Even if there isn't a compensatory claim for spousal support, there could be what we call a needs and means based entitlement, that maybe you don't have children, but you lived together for 20 years and you relied on the higher incomes, higher earning spouse's income. You don't make as much money. So maybe there's a mean, you have the need and then the person has the means to pay. So there's a lot more discretion for lawyers and judges to determine what spousal support payment is. But certainly if you're in a situation like a long-term traditional marriage or common law relationship where you have children and one person stayed home to raise the kids and their person worked, you would be entitled to spousal support. The key though is what it comes down to is what's your entitlement, how much are you going to receive, and there's no like straight table amount for that. There's they now have spousal support advisory guidelines that are advisory, that we put numbers into a computer program. This is each person's income, this is the number of children they're paying support for, and they spit out a number for a range of spousal support. The next screen is a tool that we use. If you want to go one more screen, Nina. Yeah. This is a tool that a lot of lawyers use. It's called DivorceMate software. There's also something called ChildView, and there's probably other programs out there. But this will figure out what the range of spousal support is. So just looking at the top left, I must have been watching hockey this night when I did this. If Connor Hellebuyck makes $150,000 a year, probably more like a month, but let's say he makes that per year, and he separates from his wife, and his wife only makes $25,000, and they have one child together that lives primarily with the mom. So it'll take those numbers and figure out what he has to pay in child support. And the table amount for child support is at the on the right-hand side, where it says annual guideline income 150, child support guideline table amount is 1241. So that's what he'd have to pay in child support. Then it factors in, any tax consequences, and it tells us what the spousal support advisory guidelines say would be spousal support. A range from 1939 being the low range to a high range of 2976, with the mid-range being 2448. So that would be the spousal support on top of the child support. Now, the thing to remember here, child support has no tax consequences. So if you receive child support, you don't pay tax on that. You don't put it on your tax return and have to pay tax on it. If you get periodic spousal support, say of $24.48 a month, you have to put that on your tax return as income, and you will pay tax on that. So even though you might get $2,400 a month, you should be setting aside, $600, $700 a month for your taxes, because you will get a tax bill at the end of the year. Likewise, the person paying spousal support will get a tax deduction. So if the spouse paying spousal support is paying $24.48 a month, it may only cost them $1,600 a month, because they'll get that money back in tax come tax time. There's many factors when you're looking at spousal support. You'll see at the very bottom on the left-hand side, we've inputted date of marriage and date of separation. So the spousal support numbers will depend on how long the marriage was. If there's no children and it's just a 10-year marriage or a 20-year marriage, that's put into a formula. And if you're married for 10 years, you'll have less spousal support than if you're married 20 years. So again, I don't know how to do the mathematical calculation. I just know how to put the numbers into this kind of program, and it spits the numbers out for us. It doesn't tell us what the number should be. It's a negotiation, or if you're in front of a judge, the judge will decide. Manitoba usually uses a mid-range amount, although there could be other factors where it might be low or high. Maybe the paying spouse is taking over a bit more debt and paying more debt, so maybe it's a low end. Or maybe the paying spouse does have a spouse that, like a new spouse, that also earns income, and the recipient spouse is on her own, maybe it'll be high range of spousal support. So there's different factors that would move it kind of on that range. Um, and then the duration of support, like really, there's three questions. Are you entitled to support, first of all? If so, how much? And these programs help us to kind of pinpoint how much. And then how long is it paid for? So the guideline, the Spouse Support Advisory Guidelines, we call them SAGs. The SAGs say if the marriage less than 20 years, then it could be a range, like a duration from half the length of marriage to the full length. So if you were together for 10 years, either married or cohabitating for 10 years, you could get spouse support anywhere between 5 and 10 years. If you were together 15 years, then you can get spouse support anywhere between 7.5 to 15 years. And that depends too on what happens, like, what age are the children? If the children are teenagers and it's expected that the recipient spouse, when the kids are done school, will go and get a full-time job, maybe the spouse support's kind of on the lower end of duration because the children are older and the other recipient spouse can improve their income earning and go out and get a job. If the marriage or cohabitation is longer than 20 years, it's what is considered long-term marriage, and spouse support that is payable indefinitely. It doesn't mean forever, but indefinitely being until there's a change of circumstances. So if the parties are in their 50s and looking to retire at age 65, when they separate at age 58, the payer spouse may only have to pay for 7 years until they're 65 and allowed to retire. If they separate at age 40, maybe they'll be paid for 15 years. So it all depends on each individual's circumstances, how long spouse support is payable for, and for how much. A lot of people will negotiate maybe an end date, a termination date in the agreement itself, or the court may say the payer has to pay for 5 years. If incomes change in the meantime, then the parties can go back and readdress the amount of support. So there's a lot of issues in spousal support, a lot of variables. Spousal support can also be paid on the next screen, Nina. Spousal support, sorry, spousal support can be paid in 3 different ways. Monthly payments, and that would be like periodic every month. The payer will pay $1,000 a month, tax deductible to them, taxable to the other person. That's the periodic spousal support. It can also be paid in a lump sum. So maybe the payor doesn't want to have to write that check every month. They'll just, pay a lump sum, $20,000, lump sum, no spousal support after that. Lump sum spousal supports are not taxable. So if it's agreed that the wife will pay the husband $20,000 lump sum spousal support, she doesn't get a tax break. He doesn't need to include that in his income. But maybe their incomes are close enough that the $20,000 is considered enough compensation, and then there's no spouse support paid after that. And then parties would sign, complete spouse support releases saying, I'll never pay you support, you never pay me support. That's one way of paying spouse support. The last way is one person gets more property in lieu of spouse support. So maybe the wife ends up keeping the family home, which has $100,000 in equity, $50,000 that she's entitled to, $50,000 that he's entitled to, and he agrees, I'm not going to pay spouse support, but I'm not going to get my equity out of the house. So basically, then she's getting like a spouse support payment of $50,000 because she's not having to pay him for his equity in the house or any other asset. Maybe it's agreed that the wife will keep her pension plan intact without having to share that, but that means the husband doesn't have to pay spouse support. So there's different ways to pay support. And as I said earlier, there might be a built-in termination date because maybe the wife figures I can go to school and upgrade my education, and in 5 years' time I'll be set, I'll be fine. So maybe the parties agree that he'll pay for 5 years, or maybe the situation is such that the recipient can't work. Maybe there's some medical issues that maybe they can work, but maybe not enough to really sustain themselves over the years. It might then be indefinite. Um, there's so many different ways to deal with spousal support. Those are some of the ways to deal with it. And then later on, if someone's income changes, so if the payor is paid and he suddenly gets ill and can't work anymore and doesn't have disability, he can bring an application or negotiate with the ex-spouse to either reduce or terminate spousal support because incomes have changed. Or if the recipient spouse is now making more money and doesn't need support as much, the payor can apply to have the amount of spousal support changed because it's a change of circumstances. And that would actually also apply for child support. So if someone's income goes up or goes down, child support can also be varied, like spousal support. Or there might be a built-in agreement that the amount of spousal support is non-variable for 5 years. He has to pay it no matter what. And that gives the recipient spouse the 5 years to kind of get things in order to be able to get better educated or a better job or something like that. So there's issues too when circumstances change and there's a variation to support. Spousal support can also be enforced through maintenance enforcement, the same way as child support. And they have the same means to try to collect the spousal support from the paying spouse if they're not paying voluntarily. I think that's, again, spousal support kind of bird's eye view in a nutshell. Are there any questions, Nina, resulting from any of that?
Yeah, we do have a few questions here. The first is sort of a two-part question. So for someone who hasn't registered child or spousal support through the maintenance enforcement program, what are their options for enforcement? And also, is there any way to add maintenance enforcement on after the fact if the other party is not paying?
Okay, so if you're not registered in maintenance enforcement, there are options. If it's a court order, you're allowed to garnish on any court order, if it's child support or spouse support. But really the key is to register with maintenance enforcement. There's no need for you to do garnishment when maintenance enforcement will do that for you. It used to be that the court order or agreement had to have a very specific clause in there about maintenance enforcement, to enforce. That's no longer required. So even if the agreement or court order doesn't say paid through maintenance enforcement, you can still give that court order agreement to maintenance enforcement and they open a file for you and collect it that way.
Okay. Somebody asks, if a couple separates and one party receives EIA following the separation, is there a requirement from EIA that they pursue spousal support? And if yes, would it be clawed back by EIA?
Yeah, EIA may claw back for child support. I haven't really heard of that for spousal support. But if you're not going after the other parent for child support, they may insist that you do that because that parent should be paying child support for the kids and not have you fully on government assistance. I don't know of a circumstance, and there may very well be, but I don't know personally of a circumstance where someone said you have to go after spousal support because there's so many different factors and it's not an automatic right to spousal support, whereas child support is an automatic right for the child. But yes, I've definitely seen situations where employment insurance will require you to go after the parent for support. And if you don't do it, they may claw back.
Okay, somebody else asks, when one party is on EIA and legal aid, are financials automatically reassessed or are past table amounts still apply despite there being a massive economic disparity?
The table for child support, the table amounts would apply, even if there's a big disparity. That's maybe where spousal support kicks in. That excuse me. So if someone's making $200,000 and the person's on EI, the child support would be the same, but then you can probably go up to spousal support to kind of make the incomes a little more in the same range.
But they wouldn't be automatically reassessed, right? You would have to either be registered through like the recalculation program, or you would have to take other steps to reassess, or how would that work?
Yeah, you have to take some steps to reassess. So there is a child support service that will recalculate child support annually or biannually to update for current incomes, but they won't do spousal support because it's not so clear cut. If there's a material change of circumstances, then either party can go back to court or to lawyers and say, I want to reassess or adjust spousal support for whatever reason. So that also comes to mind. The child support service in Manitoba now has expanded ability to help people. So if you don't have a court order or an agreement in place for child support, you can contact child support services and they will send out a letter to the other parent asking for financial information, like demanding financial information to be paid, to be given within 20 days, and they will do a court order. They now have the ability to make a court order that based on this person's income, he or she has to pay so much per month for children. That would help people who don't have lawyers or can't afford lawyers. They can at least get some child support being paid. And that's only if there's no other court order agreement. If there's a court order agreement, they're not able to reassess it unless it's in the child support recalculation office, which they can then recalculate, like I said, every year or every second year based on incomes. They won't do that for spousal support though, because there's so many different factors involved. They can only do that for child support.
Okay, we have a few more questions. If anybody else does have any other questions, make sure that you put them in the Q&A. We will be wrapping up soon, so maybe just a couple more that we'll take. Somebody is asking, have you noticed a shift in terms of spousal support if one person wasn't working? For example, is there a pressure on the person who wasn't working to obtain employment?
Quite often there is. It depends on the circumstances though. If you have a professional doctor who's making, $700,000 a year, and the wife was a stay-at-home, the court, and depending on her age, if she's 50 and can't really enter the workforce anymore, there'd be more obligation on the husband to pay longer spousal support. But if you are, in your 20s or 30s and still have many working years ahead of you, you can't say, I'm going to sit back and not work for 30 years. So that might affect the amount of spousal support. So depending on the circumstances and someone's health and someone's education, the court may say, we'll give you time to either get new training or get experience in this time frame, this 3 years. The payer will pay, $2,000 a month, but after 3 years, we're going to drop it down because by then you should have employment. So certainly there is pressure on the recipient spouse to, be able to work. Sometimes I've seen cases where, if a person doesn't want to work, the court may still impute income to that person. Like if the payer is making $200,000 a year and the recipient doesn't want to work, but has the experience and the wherewithal and the physical ability to work, the court may say, well, you're not working. We're going to say your income is $40,000 because you can go out and get a $40,000 a year job. The numbers would be based on 40,000 and 200, even though you're not actually making 40. So it could be imputed that way too, to the recipient spouse, and the amount of support would be lower because they're not fully out there trying to get employment to be self-sufficient. Because there's always an obligation on the recipient spouse to the best of their ability to become self-sufficient. It's not always going to happen, but just to the best of their ability.
Yeah, that's a good point. I think a lot of people don't think of the fact that recipient spouses can also have income imputed.
Yeah.
So another question that we have here, if spousal support is factored in when completing taxes, does the same rule apply to child support?
Sorry, okay, so spousal support has to be declared, if it's periodic, like paid monthly, it has to be included on your tax return as income, and you get taxed on that. Child support is not taxable, so that does not go on your tax return. there might be a line on the tax return, but it's not a line that's taxed. Like it may ask if you are getting child support, but it's not factored into your actual tax payable at the end of the day. I hope I answered that question.
I think that makes sense. Somebody is asking, do the reasons for divorce, such as adultery or physical or mental cruelty, have an impact on the spousal support amount?
Normally, it does not. Behavior of spouses really only has an effect if there's a custody issue. So if one person's quite abusive and abusive to the kids, obviously that behavior will be a factor in determining custody or parenting time of children, but not on financial issues. If it's a situation, if it's really extreme and really abusive, so that the recipient can't work and has PTSD or just physically unable to work because of it, then that may be a factor in how long support is payable. But for the most part, behavior is not taken into account when you're looking at child support or spouse support.
We have two more questions here, so perhaps we'll just do those two and then we'll wrap up. So this one asks, what resources are in place to ensure fairness for people when creating these types of legal agreements? For example, if one party has a top law firm and the other party is on legal aid, how are things like unequal power dynamics factored in by the judge to ensure transparency and accuracy when completing these calculations or equalization?
So not every file goes to the court. So many of them are negotiated between lawyers. And yes, it does make a big difference on who your lawyer is, because some are better at negotiating or giving advice than others. So definitely there might be a disparity kind of in power. If one has a legal aid lawyer and one has a paid lawyer that has a lot of experience. But bottom line is, if you can't reach an agreement because what the powerful lawyer is suggesting is not reasonable, the legal aid lawyer or the kind of the lower end lawyer can still take it to court, and the judges aren't going to side with one or the other just because of financial situation and who's the lawyer. They'll look at the facts. So if the facts are such that the recipients owed support and it's this much money, they're not going to look at who the powerful lawyer is or the non-powerful lawyer is. They're going to look at the facts of the situation. Not to say it doesn't play a part, because it certainly does, because some lawyers are better than others. One thing I tell clients, if you want a second opinion, go get a second opinion. I haven't really referred so much to CLIA, but there is a law referral service through CLIA that if you're not sure if the lawyer is telling you the correct thing or you're hearing different things, you can always phone and get a second opinion. And that might help to maybe equalize negotiation positions.
Yeah, absolutely. And there are lots of great resources on CLIA's website as well. And like Andrea said, you can definitely call our law phone and lawyer referral service just to get some information and see if the advice that you're getting from your lawyer adds up. Okay, we have one more question here. Are there any limitations or threshold requirements for making an application to vary a spousal support order? For example, if the payer's income increases by a few $1,000s, or a recipient has already applied to vary the order previously.
Yeah, I've seen cases where people go back, endlessly every 3 or 4 years to vary. It's very expensive, very expensive. Just to go to court, initially is going to probably cost $5,000, if not more. And then if you go to trial, it's going to cost $20,000, $30,000. So I always try to, avoid those situations, because they'd be spending more money on legal fees than it is worth it at the end of the day. If incomes have varied only by a few $1,000s, it's probably not worth going back to court and to renegotiate. But if they've changed their jobs and now making 50% more, then yes, it probably is worthwhile. There's no time limits. There's no limit on the number of times you can go back to court, but you do have to be able to prove the material change of circumstances, because the court's not going to open up if it's not a material change of circumstances. So a couple $1,000s, if someone's making $90,000 now making $92,000, it's probably not a material change of circumstances to open everything back up again. But if, like I said, if it's a 50% increase and I'm making 145, then yeah, of course you're going to want to go back and rejig those numbers. Um, there's also there is some time frames too. You can't just lay in the weeds as the recipient spouse and say, well, you've had higher income now for 5 years. I want you to pay, a lot of arrears or retroactive support now for the last 5 years. Um, there's time limits by the court that they only go back 3 years. Um, if you know the person's income's gone up, they're not going to go back and say we're going to make this person pay for retroactively 5 or 10 years. There's a limit to they go back 3 years, unless the payor has hid their income, and doesn't disclose their income. Then they could go back further. But there's a test for that. A pretty stringent test for the court to say to go back further than 3 years.
Okay, I think that's all the questions that we have time for today. I see that there are a couple of more that have come in the Q&A, so I've just been answering those by text. But thank you so much to Andrea for being here today and presenting to us. That was an excellent presentation, and I'm sure everybody learned a lot. And we are so grateful to have had you here today. To everybody who attended, thank you very, very much for being here. It's very much appreciated. Thank you to all of the questions. And as I said earlier, if you have a couple of minutes after the presentation today to fill out our brief survey, it shouldn't take you more than a couple of minutes. And it really helps us a lot. So that would be greatly appreciated to those who were here with us today. Thank you again. And I hope everybody has a great day and a great rest of the week.